People of the State of Michigan versus Anthony Roesly. This is file 20-23562. Mr. Roesly is here, represented by Mr. George. Mr. Gabriel is the prosecutor. We have Melinda Roesly here, who is the mother of the victim, to address the court. And we're here on 2 counts of criminal sexual conduct in the 2nd degree involving a relationship. And both of these counts are punishable by up to 15 years in prison. Mr. Roesly pled guilty to both of these counts. In exchange, the rest of the counts were be dismissed, including counts of criminal sexual conduct in the 1st degree and other counts of criminal sexual conduct in the 2nd degree. Mr. George, does Mr. Roesly have any objection to continuing on video today?
No, Your Honor.
All right, thank you. Now, are there any additions, corrections, or deletions to the report?
Your Honor, I found none in my review. I met with Mr. Roesly yesterday. We went through the report, and he had indicated that there were none.
Mr. Gabriel?
I also have none, Your Honor.
In terms of scoring, as to count 1, the prior record variable is recommended to be scored at 10 points, level C.
I believe that's accurate.
No objection, Your Honor.
And the offense variables for this count are recommended to be scored at 95 points, level 6.
I don't object to that, Your Honor.
Your Honor, I would object to OV 11 being scored at 50 points.
Let me get my book out. This is a crime against person, and OV 11 says score 2 or more criminal sexual penetrations. All sexual penetrations of the victim by the offender arising out of the sentencing offense must be counted in scoring OV 11. Multiple penetrations of the victim by the offender extending beyond the sentencing offense may be scored in OVs 12 or 13. Any conduct that is scored under OV 12 must not be scored under OV, or 11 must not be scored under OV 12. And any conduct that is scored under OV 11 may also be scored under OV 13 only if the conduct is an offense that related to membership in an organized criminal group, or for sentencing offenses committed on or after April 1st, 2009 that are gang related. The one penetration that forms the basis of a 1st or 3rd degree criminal sexual conduct offense must not be counted for purposes of scoring OV 11. So here, in terms of this count, count 1, there having been no objection to the report, and since there's been an objection, I do have to detail the reasons for the scoring. And so I apologize for the graphic nature of the report, but the report does contain that the victim, who is his sister, indicated that on the evening in question, the defendant came into the house and he was drunk. She said he masturbated in front of her, then touched her. Requested to be a little more specific as to describe, she said what she meant by masturbate, he pleasured himself. And then she demonstrated with a hand gesture as to what that meant. He then asked if he could pleasure me. She indicated that he did. When asked what that meant, he groped my boobs and touched my vagina. She indicated that her clothes were on, but he touched her boobs under her shirt. She denied wearing a bra at that time. She had pajama pants, and her brother put his hands down her pants and touched her vagina. The victim pointed in between the drawing through the labia. When asked if he was touching himself at that time, she denied that he kissed her and also denied that he ejaculated. Said the incident didn't last that long, that her brother heard something, got up, and then went to get a drink. He then lay down on the other couch. He then attempted to put his penis on or near her vagina. She denied that he put his penis in her mouth or asked her to. When asked if she touched his penis, she indicated that she did. She explained that her brother asked her to touch his penis, so she did. Inquired how he had her touch it, she demonstrated with an up and down motion with her hand. She then said that he did put his mouth on her vagina, and after he was done fingering me, he spread my legs, took my pants down, and started licking me. He pulled my underwear and PJs down. He asked her not to tell anyone and went and lay down on the other couch, and she indicated that her mother then came into the room and laid down. She then goes to describe on how it had occurred years earlier in another state when she was 5, different offenses, but that wouldn't be the basis for scoring here. So what we have here in allegations by the victim is that she touched his penis, he fingered her, he put his mouth on her vagina and licked her vagina. So there's at least 2 penetrations there. And since he pled to CSE 2 rather than 3, we can count each of the penetrations as there's not one that needs to be scored as if it was a CSE 3. That was my reading of it. Now, Mr. Gabriel, what was your reading of it? And then we'll hear Mr. George's argument as to why that's inaccurate.
Well, Your Honor, as the court both indicated just now on the record, and I was reading along, checking the guidelines also, we are, I believe the court's correct. We're dealing with the second. That was the reduction from the first, but the penetrations of the fingering in, the mouth and the vaginal area, those would both count. I think it's relatively clear, and I think it's also quite believable, given the fact that the victim did indicate on multiple occasions other things that were raised by the investigator, and she denied those things happened. She denied a number of things, but said these 2 did. So I think they're properly scored.
Mr. George?
Thank you, Your Honor. Well, clearly, as the court's well aware, my client pled to criminal sexual conduct in the second degree as it relates to this count. The argument from the defense is simply that these penetrations did not arise out of this specific offense that he pled to, and that's why we are objecting to the scoring of OV11. Thank you.
Thank you. I do find that they did arise out of the same transaction. It occurred all at the same time, all in the same evening, all at the same place. It's a connected series of events, one leading to the other. First, the touching of his penis with her hand, then his fingering her, and then his taking her pants down and inserting his tongue into her vagina, and that it all occurred in the same evening in a course of events. So I do find that there were 2 penetrations. Testimony from the victim is clear that his tongue did enter her and that his finger did enter her also. So I do find there being 2 penetrations to the basis of OV50, for OV11 to be scored at 50.
Thank you.
Any other challenges to the scoring then, Mr. George?
No, Your Honor.
All right, so in terms of this count, the offense, did you have any, Mr. Gabriel? I'm sorry.
No, Your Honor, I didn't.
All right. So 95 points, level 6, advisory guideline range of 43 to 86 months on the minimum. On the other count, again, PRV 10 points, level C. No objection to that, I assume.
Correct.
No, Your Honor.
And here, OV is scored at 45 points, level 4. Any objection to that?
None from me, Your Honor.
No, Your Honor.
All right, so the advisory guideline range in this count would be 29 to 57 months. All right, thank you. We've got the scoring done, and the advisory guidelines have now been scored. So, Mr. George, we'll hear from you, then we'll hear from Mr. Roesly, and then we'll have Mr. Gabriel introduce Ms. Roesly and hear from her, and then hear from Mr. Gabriel. Go ahead.
Thank you, Your Honor. In the time that I've been able to speak with Anthony as I've represented him in this case, find a young man who's in an odd position. obviously, as the court's well aware, there's really no prior convictions in his record. Obviously, some of the information that was revealed as part of the pre-sentence investigation report, not only from investigation from the Department of Corrections, but also from the history as told by my client, indicates that this has been something that my client has been dealing with for a long time. And unfortunately, it manifested itself in a way that has affected two young people for the rest of their lives. And my client understands that. In my communications with him, I know that he was, I felt that he was open with me and honest with me about what had happened. He didn't wish to put any more trauma on them than they had already had. And that's why, he wanted to entertain whatever plea was possible. I think one of the most interesting things that my client relayed to me when I was speaking with him was he clearly understood what the sentencing guidelines would look like, that this was very likely going to be a Michigan Department of Corrections sentence. And he said to me, what is going to be available for me so I can address these issues once I get to the Department of Corrections. I think that type of insight coupled with, just frank honesty. He's acknowledging significant behavior, as Your Honor knows, in the pre-sentence investigation report. I think it's important that Anthony take that mindset with him to the Department of Corrections, because at some point his sentence is going to end, and he's going to be re-entered into society. And I said, I told him yesterday, I said, you have to make the changes necessary so that this doesn't happen again, not only because of your liberty interest, but because of what damage it does to other human beings. So he understands that. He has insight on that. And I think he's willing and prepared to handle any type of punishment that this court is going to provide today. But I think that he has the right mindset going to the Michigan Department of Corrections, and I hope that he continues that on forward. So with that being said, Your Honor, we would simply ask that the court sentence at the bottom of the guidelines. Thank you.
Thank you. Mr. Roesly, what would you like to say, if anything?
I would just like to thank you all for your time, and that I plan to use this time that I serve to continue on with that growth mindset and better myself, so that way something like this doesn't happen again.
Thank you. Mr. Gabriel?
Thank you, Your Honor. Your Honor, we have the mother of the victim. The victim is still a minor, and therefore the mother, under the constitutional amendments and the Victims' Rights Act, does have the right to speak and give an impact statement on behalf of her minor daughter. For that reason, and it is complicated because she's also the mother of Mr. Roesly, but if Mr. Roesly wishes to speak to the court as far as the impact this has had on her daughter, then I would offer her this opportunity.
All right, thank you. Ms. Roesly, what would you like me to know in terms of sentencing on behalf of your daughter?
Well, first of all, the second this happened, we made sure, and she got into counseling. So she's at a point where she is doing very good. The counselor is extremely happy with her progress. I have talked to her regarding the incident, just as a big impact for her whole family. She told me, her focus, just like everyone else, where that help may be and whatever's available to him, is what she wants as well. She did tell me she doesn't necessarily think he needs to go to jail. Obviously, with the sentencing guidelines, that's going to happen, and to get the proper resources, that's going to happen. But my impression of her is that she would also prefer a bottom of the line sentencing.
All right, thank you. Thank you very much, Ms. Roesly. Mr. Gabriel.
Thank you, Your Honor. If it please the court, as I reviewed the pre-sentence report and having been involved in trying to resolve this case, I did have an opportunity to meet with both victims, both young ladies in this case. And the court's aware from those victim impact statements that there is a variation of requests. One victim has indicated in writing that they would like to see a lengthy prison sentence, basically, I think somewhere in the area of 10 to 15. And then the court has received a number of letters in support of Mr. Roesly. I reviewed all of those letters, and I have concerns not just with the letters, but if we look at page 2 of the CFJ 284, that first paragraph written by Ms. Albert really raises some concerns that I have. And part of that is because of my time on the pro board and looking at the release of individuals who have this form of kind of sexual deviancy appetite. And that is that Mr. Roesly indicated that he has a strong sexual appetite and was acting off of impulses. He admitted that during prior counseling sessions, warning signs had been identified. In the profession, we call those triggers. And the reality of it is that there's no cure to stop the sexual appetite. All there is the educational opportunity the person has to understand the triggers and to avoid them. And in this particular situation, Mr. Roesly didn't. We're not dealing with someone that's totally new to this. He's actually had counseling. He's learned what he needs to do, and he chose not to do it. And as a result of choosing not to do it, not only did he continue to create this problem in his own nuclear family with his own daughter or his own sister, but he reached out into another family, granted related, but still another young girl. So there's a serious problem here. I think that serious problem deserves a substantial period of time, getting to know the Department of Corrections, getting to know their sex offender treatment program, and having an opportunity to be released prior to his maximum when he convinces them that he will do better the next time. So with that, I leave it to the court's discretion.
All right, thank you. So these are always the most troubling cases. CSC cases are the most troubling, resulting in harm to children. Mr. Roesly had been accused of similar things years ago, 8 years ago, received counseling for it, was removed from the home because of it, and then after a period of time was allowed back into the home and did it again. And he did it to those most vulnerable, his sister and a cousin who was at the home. He does admit he has this issue, and he does admit that he ignored warning signs that he had learned from counseling to deal with it. The victim is doubly traumatized because first, she's the victim, and second, she's going to be considering herself as the one responsible for whatever happens to her brother and him being gone. And it's always amazing to me, but despite what occurs here, there's always this loving relationship between family members that's occurred even though despite the crime has taken place. I'm also troubled by the letters. I don't know what they thought you did that you're here for, but letters describing you as a good Christian that is a disciple, and that one person even described it as that you're going to pay for this one nonviolent offense. I don't know what you told them you did. I hope they don't think that this kind of crime is a nonviolent offense, because this is the most violent offense to commit on a minor child. So I don't put any weight into any of those letters. I get those letters all the time from those that want to tell me that somehow their faith is going to heal them, and it doesn't hold any weight. If your faith was that strong, you wouldn't be in that seat, and you wouldn't have done those things that you did. So you're a danger until you get a handle on it. The only thing that's saving you from me giving you the Tanner maximum on these is your comments today, your recognition that you have these issues and that you're gonna do some time on it. And when I say Tanner maximum, that means 10 to 15 years. The most I can do is 2/3 of the maximum sentence. You indicated that you understand you have this issue and you want to get a handle on it. You want to take this time to take advantage of whatever the Department of Corrections does. Your mother indicated that that's necessary because that's where the programming is. Although unwanted, it is necessary that you get this program. 15 years is just a moment in time for what these victims are going to punish themselves and what you've done to them for the rest of their lives. Betrayed the trust of a stranger, one thing. To betray the trust of your own family and the ultimate victim being your sister and your cousin. As her letters wrote, she can no longer be around you. The one can't be around you, can't trust you, and that hurts her. So, with that, on count one, the sentence of the court is that you serve 7 to 15 years in the Michigan Department of Corrections. Credit for 227 days served. There's a $60 DNA fee, $68 state cost, $130 crime victims assessment. On count two, the charge also of CSE in the second degree. Within the guidelines then of 3 years to 15 years with credit for 227 days served, $68 state cost, and there's not yet another crime victims rate assessment. These counts will run concurrently with each other. Mr. Roesly, you're being provided 3 forms advising you of what your rights on appeal are. I'd ask you to sign 1 copy acknowledging that you received them. If you wish to appeal, you need to fill them out, return them to the court within 42 days. The financial obligations that I ordered are the state mandatory costs related to any crime. I don't have any discretion in those, and they are due and payable today, and whatever's unpaid at the end of 56 days will increase by 20%. Mr. Roesly, Mr. Gabriel, and Mr. George and I all understand that the Michigan Department of Corrections has a program that's available to sex offenders, and you'll be entering that program. But if you don't take advantage of that program, and if they don't see you making changes, you'll be doing the full 15 years. So I would encourage you to look back at what you did, accept responsibility for what you did fully, and find out how and why to deal with it, and then be able to be eligible for parole at some point. Otherwise, it's only going to be 15 years, but it's going to be the full 15 if you don't take advantage of the program. All right, thank you, everyone.